If you believe the strength of America depends on its courts actually working, then stay with me for a moment. What unfolded today wasn't just another headline about a courtroom clash. It was a moment that forced the system to reveal whether it still has a backbone when powerful people decide they don't like the answer. This morning, inside a federal courtroom in Manhattan, something happened that seasoned court watchers say they almost never see. In the middle of a live proceeding, while the judge was still speaking, 3 elite defense lawyers quietly gathered their files, stood up, and moved as if they were leaving the room. Not during a break, not after an objection. Right then, right there. Think about that for a second. These weren't spectators. These were sworn officers of the court, lawyers who know the rules better than almost anyone, and they appeared ready to walk away from their own client because a ruling didn't go their way. To understand why this moment mattered, you have to look at what led up to it. The day started normally enough. Lawyers arguing over documents, the prosecution pushing to include financial records, the defense pushing back, routine courtroom friction. But hanging over the room was something far more serious, something that had almost stayed hidden. 2 days earlier, a sealed court filing briefly became public due to an administrative mistake. It was visible for only minutes, but that was long enough for legal analysts to see what was inside before it vanished again. According to people who reviewed it, prosecutors had uncovered communications and financial activity that directly contradicted earlier claims made by the defense. Not small details. Millions of dollars in transfers, encrypted messages, and what some called an unusually tight paper trail. This morning, the judge ruled that all of that material could be presented in court. Hundreds of pages. Fully admissible, that ruling changed the temperature of the room instantly. One of the defense attorneys stood up and accused the court of no longer being fair. Another followed, saying they refused to be part of what they claimed was an unjust process. Then they turned toward the exit. That's when the judge stepped in. This is important context. The judge in this case isn't known for drama. She's been on the federal bench for decades. Appointed by a Republican president. Respected across ideological lines. Lawyers often say she's exactly the kind of judge you want if you believe in a fair shake. She didn't raise her voice. She didn't argue. She simply made the stakes clear. If they took another step, she said, they would be held in criminal contempt. Arrest warrants would be issued immediately. U.S. Marshals moved into position and blocked the exits. No one left. For several tense minutes, the room stood still, and then came the moment that explained everything. The judge disclosed that she had received a highly unusual submission from the Justice Department that same morning, one the defense had not seen. In federal court, this almost never happens. Judges avoid one-sided communications unless there is a serious reason, threats to safety, national security concerns, or risks to witnesses. Based on what she had reviewed, the judge said she was weighing additional security steps and even the possibility of isolating the jury. Every experienced defense lawyer knows what that signals. It means the case may have crossed a line. From aggressive prosecution into territory where the court believes there are real risks beyond legal arguments. Risks that go beyond reputation or money. That's why those attorneys tried to leave. Not because of theater, not because of emotion, but because they understood in that moment how serious the situation had become. This wasn't about one ruling. It was about the system asserting that no one gets to walk out just because accountability suddenly feels real. And that's why today wasn't just another courtroom story. It was a reminder. The rule of law only works if it applies even when powerful people wish it didn't. Prosecutors aren't just building a case from documents anymore. They have a person. Someone who was close. Someone who knows how things actually worked behind the scenes. In other words, someone from the inner circle has decided to talk. Former federal prosecutors explained it plainly on TV within hours. When defense lawyers hear that a judge has received a secret, one-sided submission in a case this big, they don't guess, they know. It usually means a cooperating witness is about to surface, and that witness has information the defense never prepared for. That's when panic sets in, and suddenly everything that happened in that courtroom starts to make sense. Because once the lawyers sat back down after that tense standoff, they didn't calm things down. They escalated. Within half an hour, they filed emergency motions accusing the judge of bias and misconduct. They demanded a mistrial. They asked that the judge be removed from the case altogether. And here's the key point most people missed. That dramatic attempt to walk out created the very controversy they needed to argue those motions. This wasn't just about today's ruling. It was about building a record, one that could be used on appeal no matter how the trial ends. Legal experts across the spectrum agree on this. The performance wasn't aimed at the judge. It was aimed at cameras, headlines, and a political audience far outside that courtroom. And the timing raises even more questions. Reporters were already in position outside the courthouse before the walkout attempt happened. Commentators were posting about judicial overreach before most of the public even knew anything unusual had occurred. That doesn't happen by accident. That looks prepared. Now consider what the judge revealed next. The sealed submission she referenced reportedly concerns testimony scheduled for next week from a person identified only as Witness 14. According to people familiar with the case, this witness has direct knowledge of the financial transactions prosecutors say are at the heart of everything. This person has reportedly been under protective custody for months, the kind of protection reserved for situations involving serious danger. That alone tells you how high the stakes are. Legal analysts believe this witness may be someone deeply embedded in the financial operation, someone who didn't just see the numbers, but managed them, someone whose testimony could connect dots the defense desperately wants kept separate. And here's the part you can't ignore. The attempted walkout happened just days before this testimony is expected to begin. That's not random. After order was restored, the judge made another move that sent shockwaves through the legal world. She said she was considering appointing backup attorneys, shadow counsel, to sit in the courtroom and be ready to step in instantly if the defense tried something like that again. That's almost unheard of. It's what courts do when they believe a defendant's own lawyers may jeopardize the trial itself. It's the legal version of saying, this case is too important to be held hostage by theatrics, and the consequences aren't stopping at the courtroom door. Financially, the defense team is now under serious pressure. Reports indicate their firm has billed tens of millions of dollars so far, and behind the scenes, their malpractice insurer is reportedly asking hard questions. If the court determines that the lawyers' conduct endangered the trial, the financial fallout could land personally on the partners themselves. That explains why senior figures at the firm were seen rushing into emergency meetings late at night. This isn't just about one client anymore. It's about professional survival. But the biggest issue here goes far beyond one trial, one defendant, or one judge. If lawyers are allowed to stage walkouts whenever they don't like a ruling, the justice system stops functioning. Every future defendant could try the same tactic, disrupt the trial, provoke a reaction, then claim unfairness. That's why the judge drew such a hard line, and history backs her up. The few times lawyers have tried this in major federal cases, it's ended badly, not just for their clients, but for the lawyers themselves. Disciplinary action, career damage, convictions that stood. The pattern is unmistakable. The political reaction was immediate and explosive, as you'd expect. Supporters framed it as resistance. Critics called it sabotage. But here's what cuts through all of that noise. Public opinion didn't follow the script. Polling showed that a strong majority of Americans, including many Republicans, rejected the walkout attempt. Most agreed that lawyers don't get special rules, and neither do former presidents. Even prominent legal defenders who usually take the most aggressive positions refused to justify what happened. When people who normally defend everything draw the line and say, no, this crossed it, that tells you something important. This wasn't just aggressive lawyering. It was a gamble, one that may have exposed just how close this case is getting to something the defense cannot control anymore. And that's why this moment matters. Not as spectacle, not as politics, but as a test of whether the rule of law still holds when the pressure is at its highest. Just minutes before the defense team stood up and tried to walk out, something happened behind the scenes. According to someone working with the defense, a message landed on lead counsel's phone moments before the chaos began. 2 words, no explanation. Just abort mission. The source says the message didn't come from another lawyer. It came from a political strategist, someone advising on optics, not law. If that's true, then what unfolded in that courtroom wasn't a legal reaction. It was a calculated move. A performance designed for cameras, headlines, and supporters, not for the judge. And it appears the court noticed. Later that evening, the judge issued a written order that stopped a lot of people cold. In it, she said she had reason to believe parts of the day's disruption were coordinated with people outside the courtroom and had nothing to do with justice. She warned that if the trial was turned into political theater again, the consequences would be severe. Arrests, fines, and referrals that could end legal careers. That's a federal judge, on the record, saying she believes a courtroom stunt may have been politically engineered. After the morning turmoil, security snapped into overdrive. This wasn't routine caution. Extra metal detectors went up. Police flooded the perimeter. Federal agents were placed on alert. Inside the courthouse, the atmosphere shifted from tense to volatile. At one point, a note was quietly handed to the judge. It came from court security. They had identified individuals connected to extremist groups lingering near the building. No confirmed threat, but enough concern to raise alarms. The judge reportedly made it clear any attempt by either side to inflame the public would be met with the full force of federal law enforcement, and the world was watching. Legal observers overseas reacted with disbelief. In other democracies, commentators said lawyers behaving this way would be detained on the spot. Foreign media framed the scene as evidence of instability in the American justice system. Predictably, hostile state outlets seized on it as proof that U.S. institutions were cracking. That alone should worry anyone who cares about credibility, not just of this trial, but of the system itself. Now here's the part that may matter most going forward. Sources close to Trump say serious conversations are happening about firing the entire defense team. The names being floated are extreme, lawyers known for scorched earth tactics, the kind who thrive on spectacle and chaos. The mindset, according to insiders, is simple: if this is going to end badly, make it as loud and disruptive as possible. That puts the judge in a no-win situation. If she allows the current lawyers to quit, the trial could be delayed for months while replacements catch up. If she forces them to stay, the defense will argue later that their client was denied effective representation. One legal expert described it as brilliantly cynical, a trap designed so that every option damages the court. Meanwhile, prosecutors are reportedly weighing an aggressive move of their own, asking whether the defendant's bail should be reconsidered based on the conduct of his legal team. It's a long shot, almost certainly unsuccessful, but even raising it would send a powerful message and dominate headlines. And then there's the jury. They didn't see the walkout attempt itself, but they felt the aftershocks. The tension was unmistakable. Observers noted jurors watching the defense closely, reacting to the judge's remarks, scribbling notes during moments of confrontation. Jury specialists say scenes like this rarely help the defense. To jurors, it can look like desperation, like lawyers taking risks because the facts aren't on their side. You don't need legal training to read that signal. On Monday, the judge will make decisions that could shape the rest of this case, whether to grant a mistrial, whether to step aside, whether a key witness will testify as planned. She has also made something else very clear: any repeat performance will end with lawyers in handcuffs. Federal marshals have reportedly been briefed on arrest procedures for attorneys, a step so rare that longtime court staff say they can't remember it ever happening. Now zoom out. This is all unfolding with an election less than a year away. Every day spent in that courtroom is a day not spent campaigning. Some analysts believe the disruption wasn't just about today. It was about trying to blow up the timeline, force delays, and push any resolution past Election Day. That's the gamble, using a courtroom not as a place for justice, but as another political battlefield. And that's why this story isn't really about one outburst, one judge, or one legal team. It's about whether the justice system can still hold its ground when pressure, power, and politics all collide at once. Judge Caldwell, for her part, seems intent on stopping this from spiraling any further. People familiar with her approach say she's ready to do whatever it takes to keep the trial moving, even adding extra court days if necessary. She's also weighing whether nonstop media coverage is fueling the behavior, and if so, whether tighter limits are needed to restore discipline inside the courtroom. Because what happened wasn't just a legal tactic, it was an attempt to turn a federal trial into a spectacle. When lawyers feel comfortable defying a judge, when a criminal courtroom starts to resemble a campaign rally, when justice begins to look more like entertainment than truth-seeking, that's when something fundamental breaks. And it's not just critics saying this anymore. Even members of Trump's own party are stepping back. Statements from Republican senators made one thing clear: aggressive defense is one thing, but walking out on a federal judge crosses a line most people never imagined would need to be drawn. When even reliable allies start choosing their words carefully, it's a sign the strategy has gone too far. The real harm here isn't limited to how this case ends. Every American, regardless of politics, depends on a system where rules apply evenly, where money, fame, or influence don't buy a different set of standards. When lawyers try to escape rulings instead of challenging them through proper channels, it sends a dangerous message that with enough resources and nerve, the system itself can be bent or broken. That isn't justice. It's disorder dressed up as advocacy. And if this approach succeeds, if turning trials into spectacles becomes normalized, it won't stop here. Any wealthy defendant could try the same playbook. Courtrooms would become stages. Judges would spend more time maintaining order than weighing facts. Verdicts would be drowned out by outrage and performance. That's not a justice system. That's the collapse of the rule of law in slow motion. So now everything hinges on what happens next. Can the court reassert control? Will the defense double down on disruption? And can the legal system withstand this kind of pressure without losing public trust? Those questions will be answered soon, when key testimony begins, when the judge rules on the pending motions, and when the truth behind today's chaos finally comes into focus. Because this is no longer just about one defendant or one courtroom. It's about whether we still believe, not symbolically, not rhetorically, but in practice, that no one in this country is above the law.